Hello, this is Bhavna Rajput. Good morning, everyone. Uh, my today's topic is copyright, meaning and concept, meaning and scope. So let's begin with the topic. What is copyright? So before indulge into the discussing that what is copyright, we need to indulge that what is intellectual property right actually. Intellectual property rights, copyright is a subject of intellectual property rights. So we need to understand what is intellectual property rights. As we know what is property, as per the as per the jurisprudential definition of property, we know property is something on which we have exclusive rights, all rights, uh, such as right to use, right to transfer it, and right to such of dispose of it. So intellectual property, and we know that property is of two kinds, like tangible property, intangible property, corporeal property, non-corporeal property. Tangible property is something that we can feel, we can touch, which we can feel, what we can feel physically. And intangible property is something that we cannot feel it. There is a presence of it, but we can physically not feel it, we cannot touch it. So intellectual property is something that is intangible in nature. We cannot touch it, we cannot feel it, but it exists and it's beneficial to the human being, and we have all the rights which we have upon the property, like right to use, right to transfer, and right to dispose of it. So intellectual, what is intellectual? A discussion, a knowledge. So a property that is derived from someone's knowledge is the intellectual property. And intellectual property mainly consists copyright, uh, patent, and trademark. For today's subject, for today's discussion, my subject is copyright. Let's begin with the topic. What is copyright? Copyright refers to the right to copy, which means right that only creator owner has with respect to his or her original work. A right to reproduce, right to distribute, right to display or transfer to another person. Without taking the permission of an author, no one has a right to play with intellectual property. Section 14 of the copyright defines the right of the owner which he gets under the copyright protection. Right, copyright actually provides an exclusive right to the creator of something, some original work, to commercially use it, to exclude other from using it. Because if someone using his mind and skills and labor is making something, then that someone has a right to exploit it. Huh? Who create has all the right upon the thing. The creator has all the right on his creativeness. So copyright is form of the protection for the creator who produce original work, but does not protect the facts, ideas, system, methods of operation. Individual often confuse copyright, patent, and trademark. Copyright protect the original work of author, while a patent protects innovation and discoveries, and trademark protects symbol, phrases, and designs. If I'm talking what is the subject matter of copyright, Article 13 of the Copyright Act clearly defined that copyright subsists in original literary work, dramatic work, artistic work, musical work, cinematography work. Initially, sound recording was not the part of copyright, but after the Star India, while the cases of Star India Private Limited, sound recordings was also recognized as the subject of copyright. So, what is actually literary work? Any, I would like to clear it that anything which is subject of copyright, that should be original. And what is the meaning of originality? In context of copyright, originality does not mean that something very new or novel. No, originality denotes that some has some kind of distinct feature and some kind of no, some kind of innovation. So, if we talk about what is literary work, any work written or printed or can be reduced to writing in any language, whether it's poetry, whether it's a history, whether it's a book, periodical, table, and any written subject, is literature. It also includes computer programs, table, compilations. It includes school textbook, question papers, set of question papers, side note, margin notes, head note, reports, research theses, catalogs, contract form, directories, and many more. Even the guidebooks are also the part of, even in a case it is decided the railway maps, railway time schedule is a part of is subject of copyright. So copyright subsists in the original adaptation of another's literary work. Because the adaptation may be itself a literary work, adaptation in relation to literary work means the conversion of the work into a dramatic work by way performance in the public or otherwise. So words and slogan, sometimes word and slogan, if it has a specific meaning and it's some kind of originality, is also the subject of copyright. As we know, Netaji Subhashan, the slogan of Netaji Subhashan, "तुम मुझे खून दो मैं तुम्हें आजादी," when these kind of slogans was created by someone, it might be subject of copyright. Similarly, if someone created a fictional character that has some kind of uh, distinctive features, that is also the subject of copyright. In case of Arbaj Khan Protection Private Limited versus North Star Entertainment Private Limited, it was decided that any kind of a character, the any kind making of creating of any kind of character that has some kind of specific distinctive feature is subject of copyright. So similarly, abridgment, when someone adopted work, a literary work, uh, into a dramatic, the adaptation is also the subject of copyright. Adaptations means conversion of a work into another kind of work. When a literary work convert into the performance, dramatic performance in a cinematography, that is adaptation. Abridgment, when a large work, as the huge amount of work penned down and reduced down to a summary, it is the abridgment of work. It is also protected under Copyright Act. The next subject of copyright protection is dramatic work. Any piece, what is drama? Any piece of recitation, choreographic entertainment in a dumb show, the scenic arrangement of acting from which it is fixed in writing otherwise, but does not include a cinematographic film. If I'm talking the literal meaning of dramatic work, then any work that can be being performed before the audience and includes the hand movements is a dramatic work. In case of Norway versus Arc Limited, it can be held. It was held that it can be performed before audience and it can be perceived and appreciated by the eyes. Anything that's include body movement is a dramatic work. But for providing a copyright protection to a dramatic work, it is necessary that it can be reduced to the writing, and it is irrelevant whether the dramatic work includes words or dialogues or not. Similarly, choreography is also the subject of copyright. uh, Institute of Inner Studies versus Charlotte Anderson, it was said that the what is choreography? Any kind arrangement of body movement and a face gesture. It includes the arrangement of body movement and a face gesture. And for the protection of copyright, it is necessary that choreography also can reduce to the writing. It might be in words, it might be in sign, but it is necessary for the protection of copyright work that it should be reduced to the writing. Similarly, in case open source yoga, in this case it was decided that the yoga steps, the hand movements for any physical activity cannot consider choreography and it cannot be a part of choreography. When someone indulges a yoga movement as a part of choreographic performance, then it might there are some possibility that it can be included in choreographic work, but separately the hand movement for the physical activities like yoga cannot be a part of choreography. Scenic arrangement is also the part of dramatic work when a distinct kind of scenic arrangement has created for signify to provide a message. That is also the subject of copyright. If we talk about musical work, a work consisting music and include any graphical notion of such work, but does not include any work, any action intended to be sung, spoken, or performed with the music. And so, in generally, if we talk about the musical work, the represent what actually when hear a song, then what is the music, the tone behind the song, the words of the song comes under to the literary work, but the music, the graphical notion, the graphical representation of that tone is a music, and it is also necessary for the copyright protection that it can be reduced to the writing. So if we see the musical of the definition of music, the consisting of music can include production of a combination of sound that to be appreciated by the ear. Star India Private Limited versus Pius. In case of Star India Private Limited versus Pius Agrawal, it was held that earlier sound recording wasn't part of copyright protection, but now sound recording can be considered as the subject of copyright, and copyright subsists in copy as well. Artistic work, art that is appreciated by the eyes. So art is consist many things. Artistic work is an umbrella term, and it consists many things: a painting, a sculpture, a drawing, a map, an engraving, a photograph, any work of architecture, and any work of artistic craftsmanship. We can term them all of the worm as a artistic work, and they are also similarly protected under the copyright. Similarly, cinematography, any work of visual recording or any other medium through a process from which a moving image may be produced by any mean and includes a sound recording. Accompanying such visual recording in cinematography shall be construed as including any work produced by any process analogous to cinematography, including video films. Uh, as I earlier said, the books was the first thing that got protection under the copyright, but the sound recording was a thing that was initially earlier not protected by the copyright, but after the case of Star India Private Limited versus Pius Agrawal, sound recording was also considered as a subject of copyright. And copyright in a sound recording is a separate form of the copyright in any work from which or from a substantial part of which the sound recording is made. The former will not affect the later. In case of a recording, copyright means to do or authorize the doing of any of the following acts by utilizing the records: to make any other records embodying the same recording, to cause the recording embodied in the record to be heard by in public, to communicate the recording embedded in the record by radio diffusion. Uh, so these are the subject of copyright. But as I say, that copyright should consist some kind of originality. But if we see the theory of copyright, there is no copyright over the ideas. Copyright is something someone can claim copyright on some kind of material that is exist, but there is no copyright exist on the ideas. An abstract idea is not protected, but what is protected is the material form in which idea are translated or expressed. A person may have a brilliant idea for a story or play, but it is the production, which is the result of communication of the idea, is the copyright of the person who has clothed the idea in forms. And the owner of the idea has no right in the product. In case of, there are so many cases in which it was decided that copyright is something in already existing thing. If someone take a similar idea and a similar ground and create some kind of work that has some kind of distinctive features, some kind of merit, then it cannot be said the copyright over the idea is infringed or the idea was theft, because there is no copyright upon the ideas, or only the original work that already subsists is protected under the copyright protection. In in case of RG Anand versus Deluxe Films, Justice Fazil Ali laid down the following proposition. In this case, the producer of the play, Hum Hindustani narrates the play to the defendant who made a picture, New Delhi, which was alleged to be based on the same play. In this case, it was held that there is no copyright on the ideas. Copyright subsists only on something that has been quote that had been existed. Similarly, in case there was another case in which a producer communicate his idea to a person communicated his idea to someone, and that to create a reality show on Swayamvar when a girl is being chosen to is choosing his husband, his future husband. The same idea that there was another show that was released by the name of Shubh Vivah. In this case, it was already said that the idea of the show was told by the person. But again, in this case, it was expressed by the court that there is no copyright on the ideas. But in this case, the plaintiff contested that he not only communicated or narrated the idea, but also provided the concept note to the defendant. Then it was held that if some idea has been clothed or reduced to the concept note, that we cannot say that it is mere idea. It is also, we can say that there is something that has been reduced to writing that has some kind of physical value, and that cannot be still, that cannot be said only an idea, mere an idea. If we talk about the ownership of copyright, who is the owner of any kind of creative work with reference to the copyright, as uh, I have cleared that the copyright subsists in literary, dramatical, musical, artistic work, photographs, cinematography, sound recordings, computer generated work. Then the question is the next question that is arise before us is that who is the owner, who owns copyright upon them, these subjects. So first of all, the very essential thing to decide the ownership is that someone who created someone by using his intellect, by using his labor, his skills, is the person who actually created, and he is the owner of the copyright. In case of literary or dramatic work, the author is the creator. In case of musical work, the author is the creator, and in this case, author denotes the person who composed that graphical notes. The composer holds authorship upon any musical work. For artistic work, for the artistic work, the artist who created the thing is the owner of copyright. And in case of photographs, the person who clicks the picture, the photographer, is the author. If I say the cinematography film, the person who initiated the action, the one who taking all kind, that who is in decisive role, who take the person who takes the initiation of the risk is the producer, the person who gathered other people for the purpose of sound recording. Again, the producer, the person who initiate the action is the author. And generally, in case of cinematography and sound recording, the person is the producer. For the computer generated work of literature, drama, music, art, individual communication work, the the person who is creating, the person who caused to be it created, is the author of the work. But if I say, when someone is creating something under the course of employment and he is getting paid for the creation, then the person who is paying them, who is the employer, is the author. But if someone is creating a work in course of employment, but that is not anyhow is associated to the employment, and directly he make it for his convenience, then it is a general work of creation which is beyond from the course of employment. Then the copyright subsists in the author and the creator. Thank you. Thank you all for today's lecture. Mhm. कोई नहीं रहा।